0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I wanted to reject it, and then I wanted to see, at that point in time, because I was, I was incompetent at one point.
Okay.
Right away, the stakes are crystal clear. The judge isn't discussing a minor charge. Haresh is outlining a potential sentence that could stretch from 2 to 20 years behind bars. This is one of those moments where every decision matters. And hey, raise the question, if you were offered 8 years today, would you risk a trial knowing the sentence could be much worse?
I was out of my mind, which I have a history of it before.
Okay.
Mental health.
Okay.
But I just wanted to say on document from everybody that in my mind, my heart, my mind was so I would never hit office.
Well, so
This is a situation that I'm in.
The allegations allege alcohol and drugs.
and is there a video?
That's what I was asked. I wanted to.
Hold on.
Oh, yes, sir.
I didn't see a video on Discovery. There may be, but I don't.
I have
haven't seen
a
one.
thumb drive in my drawer.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video, and then he can come show it to you.
This is a surprisingly important courtroom moment before anyone makes a life-changing decision. The judge wants the defendant to see all of the evidence, especially the video. That's actually a fundamental part of the process. A plea decision is supposed to be informed, not rushed, and notice how quickly Mr. Mills' confidence about going to trial starts to shift once the possibility of video evidence enters the conversation.
You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, ma'am. Your Honor, I really don't want to go to.
well, that's what,
It's kind of.
I want you to see everything. I'll give them some time to get that taken care of, and then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
Okay, thank you.
All right, you can go back with the
Can I
baby.
ask you one more question?
Yes, sir.
In a situation of that situation, did probation ever come across the table?
That's between your lawyer and the district attorney's attorney. It's whether or not they offer
I
it.
wouldn't. Okay, thank you.
Okay. I'm just going to delete the rejection if it's we'll do it again later if that's the case.
Now the pressure level jumps dramatically. Habitual offender enhancements can completely transform a case. What might have been a serious charge suddenly becomes a potential decades-long prison sentence. When defendants hear numbers like 25 years to life, plea offers that once sounded harsh can start looking very different. This is where courtroom strategy collides with reality.
All right. Good morning, sir.
Good morning.
Are you Samuel Jones?
Yes,
And Mr. Jones, in cause number 25 DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to
Pay close attention here, because this is one of the most significant legal decisions a judge can make before trial. Competency isn't about whether someone is guilty or innocent. It's about whether they understand the proceedings and can assist in their own defense. If that ability is in doubt, the entire case can pause until the issue is resolved.
trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment, guilty and those prior offenses are true, is 25 years in prison up to 99 years or life. Do you understand? And I need you to answer yes or no, please.
yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are. And you want to reject that offer and have both cases.
What makes this situation tricky is that this defendant isn't dealing with just one court. A plea in one county could trigger consequences in another. That's something many people never realize. Criminal cases often create a domino effect where one decision can impact probation, pending charges, or sentencing somewhere else entirely.
And so you also have, and let me go through this too, just for the record. In cause number 25 DCCR 0232, you're charged with burglary of a building, a state jail felony, and that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes.
Okay. And you want to reject that offer and have your case set for trial?
Yes.
All right.
And I'd like to indict everybody who have witness. I'd like to indict everybody who caused this case, signed the case.
Okay. So,
Fingerprints, evidence, and everything. I want everything to be everybody indicted.
He's complained about some charges that other counties have explained that doesn't have anything to do with here.
So
He wants
here,
everybody here, and I told him everybody will have to be here at trial whenever.
yeah, I mean, whatever the district,
Well,
listen.
I want to let you know I'm 17 code. My code is 774 is my badge number. 477 Barras, Bear County, Patrol Detention.
Okay.
Private detective and everything.
Okay.
Private investigator.
All right. So here's what we're going to do before we move any further.
And that's the hidden side of the justice system. Most cases never reach the dramatic trial scenes people see on television. Instead, they're shaped by evidence reviews, plea negotiations, sentencing risks, competency questions, and strategic timing. Every defendant in this courtroom is facing a different calculation, but they all have one thing in common: a decision made today could affect years or even decades off their future.